Hello, Angela Jackson. Hello, hello. Hello, Angela Jackson. What's good? What's good? What's good? First of all, oh my gosh, I got to apologize to Levi. I think it was Blessed One and everybody that was in his chat because at some point on that live, I checked out. I politely rolled over and baby, it was on from there, baby. It was on. But a dude by the name of Omar Harris came in the chat last night and he said that there was paperwork. All right. I didn't give a damn about none of that. And then I didn't even see it on the thing, so fuck that. I wasn't caring. I wasn't trying to look. I wasn't giving a fuck about it. But you know, with this whole thing, right? I'm a type of person that I like to see I like to see things through, right? I never thought that it would be motherfuckers going to jail, getting arrested, getting their ass beat, people doing all kinds of shit, whatever. When I decided just to hey, just do what I want to do. You know what I'm saying? And I'm going to always do that. And I'm going to take very little advice from out here or instruction. I'm gonna tell you why, because that's not usually how I operate, right? Because the advice and instructions I get are from people with good sense that mean well and have your best interests in mind, not just theirs or whatever. You know what I'm saying? So I'm not in a I'm never going to be in a rush to be first or whatever. I want to be accurate. Okay. And then once again, there ain't a motherfucker out here has been more accurate than we have, other than the motherfucking prosecution. Okay? Go check it. Who you talking to, me? No, fool, I'm on live. Oh, shit. Hold on for a minute, y'all. Hold on. My apologies. Anyway, I don't even know. I had such a meaningful thing to say, but never mind. What is it? Anyway, oh yeah, I know I was. So, what's good is Sonya Davis. Hey, Karen J. Howdy, howdy. Yes, what's good with it, Warrior Aphrodite? So, I find that, people out here give you advice based on their own personal agendas or whatever narrative they want you to help them participate in or their feelings. Like they tell you who they you should have on your channel. Nobody. Oh my gosh. I don't play that. I don't play nobody. You know. Come to me with that bullshit. Cause you would be the one that will get it. You know. And I called it just right. You know what I'm saying? You have motherfuckers that okay. Let me pull back. Because I'm not going to get in an argument with nobody about nothing. Not a back and forth or none of that bullshit. So, but anyway, But I find that a lot of you motherfuckers are just disingenuous, and there's nothing no one can do about that. There's no quick fix or nothing. That's some shit that should have been handled somewhere during birth to whatever. You know what I'm saying? I don't know what's wrong with some of you motherfuckers. You got people that's about to jump overboard over relationships and shit like that. It's this is crazy. Whether it's blood, cook, all I don't know. Y'all make it so confusing. I'm like, And you know what? But listen, when I tell you, when Mr. Niece do those goddamn reactions and those reports to the report side of him, you have to holler, okay? She does it in such in a authentic, original way where it's not picking a side or slandering anybody, whatever, and it's funny as fuck. Yeah, but she don't leave the videos up long enough for you to get there. Oh my gosh, girl, you have to have a goddamn a low jack on Mr. Niece live and she would take them motherfuckers down. You wake up and you say, oh, all you see is just a placemat where she was live. The shit gone now. So, but anyway, oh, that shit is so, oh my god, she had me cracking the hell up. But anyway, so we are going to get to another, you know, another fucking, let me pull this up, hold on. Another piece of paperwork that Jabo has dropped. Now, remember when I told you guys that, the arguments that she's raising, whether they have some merit to it or not or whatever, I know that she is skilled enough to know what the deal is. Because here's the thing, right? When it comes to post-conviction phase, right? That's why it's almost you would do yourself a disservice with going in that phase with just a regular trial attorney or with a trial attorney that does not have any experience in that area, because it is so much bullshit that goes on, right? You are dealing with errors at that point. And some errors you can bring up at certain stages of the process, right? Some errors you can bring during post-conviction motion phases, some on appeal, and then some on 2255, right? But it all deals with errors, and there's so many different errors, and they are all handled different ways, right? And I don't know what to tell you, but I think she is going to explore probably all of them that she can before it's said and done. Because you're thinking about these as two different cases, right? Two different cases. She can pencil whip. She can whip your ass with that pen. I'm gonna tell you so. But I was able to read just a few sentences of it. But I said, oh boy, this is gonna be fascinating. So let me go ahead and start reading. Give me one moment. Let me blow my nose real quick. All right, sorry about that, folks. So what I am seeing is what I have been predicting all this time, is that the arguments, the objections, the arguments she's making, her filings, all seems like it's a backdrop for several different plays. More notably, constitutional violations, right? Denial of the defendant's rights by any means necessary. Ain't nothing wrong with that. That means, shit, you get yourself caught up in some bullshit like this. This is what you need. Somebody that's here that's going down with the ship. They're gonna go down fighting. But anyway, so let me read it. So it's 8 pages. Thank God. It says motion for a new trial pursuant to Federal Rules of Criminal Procedure 33, which is 33 is new trial, 29 is acquittal. It says where the government concealed impeaching evidence that Jane hired a legal and expert team for the purpose of seeking $13 million in restitution from defendant and falsely testified about it at trial without correction from the government. Okay. Okay. All right. You have to watch how you word a lot of these things, right? Because, we all know that they're all allegations. Even indictment is allegation, right? We do know that these are considered persuading arguments, right? In form of text, persuading documents. But while you cannot just come out and tell a lie, you have to carefully word your allegations so that they're not perceived as being you just flat out lying. Okay. So you can say some things and you may not have the supporting, evidence to prove your claims when you submit them here, right? And we've seen a lot of this occur, and we've seen, attorneys get, called out for this, right, by other attorneys. Okay. So anyway, it says now comes the defendant, Robert Sylvester Kelly, by and through his counsel, Jennifer Von Jean, and moves this court to grant a new trial where defendant's due process guarantees were violated, where the government's key witness, Jane, denied during her trial testimony that she had made a decision about whether she would seek restitution. In truth, Jane had already hired a lawyer and a team of experts to prepare a restitution package for this court that the government presents in support of its claim that Jane is entitled to a whopping $13 million in restitution. And I like J-Bo because she don't always keep it professional. She used whopping in there. Okay. It says, because the government knew Jane had hired a lawyer, an expert team to create a restitution package for which Jane paid 55 grand. Wait a minute now. From a restitution package for which Jane paid $55,000 that she seeks to pass along to the defendant. Oh, this is going to be interesting. I ain't read all this, y'all. Okay. And failed to disclose this information to the defendant, and then failed to correct Jane's false testimony on the subject matter during her trial testimony. Defendant's due process rights under Brady, Giglio, and Depew were violated, and he is entitled to a new trial. Okay. Once again, you see she's trying to raise this issue to the level of prosecutorial misconduct. Hell, before it's all over, let me see. Okay. If okay, testimony is evidence, and if all this came as an evidence, then this might be subject to a harmless error review if brought upon appeal to see if it's reversible or not. I don't know. I might be thinking ahead, but let's see. Okay. So you see, she said because the government knew. All right. Remember, I told you, just like with the motion to compel, that she pushed through on in Illinois. This is pretty much a same attempt because the government knew. All right. It's already looping the government into this whatever she's going to allege in this document. Okay, so right there she said it constitutes Brady, Giglio, and the Pew. So meaning that information was not disclosed to the defendant, right? Which, based on that information, the defendant could have used it in several different ways, right? Could have used it to shape the testimony, the way they questioned the Jane Doe. In this case, Jane Doe would be RL. Could have used it in if they were to question any, the expert that may be connected to this particular evidence. Who knows, right? But let's just read it. It says, number one, Federal Rules of Criminal Procedure 33 provides that the court, on motion of a defendant, may grant a new trial to that defendant if required in the interest of justice. Remember, I was using that language more often, in the interest of justice. Fundamental miscarriage of justice. I like to tell y'all some of the terminology, some of the things that you're going to hear and see during this phase, during this process. It's just an effort to get your persuading argument seen, by the appeals court, to get some favor by the judge, and during the post-conviction motion such as this, right? It says the Seventh Circuit has interpreted the interest of justice to require a new trial in situations on which the substantial rights of the defendant have been jeopardized by errors or omissions during trial. Okay, remember I was telling you guys about errors, right? I was telling you guys pretty much about procedural errors and structural errors, okay? But there are so many more. Okay, there are prejudicial errors, there are trial errors, there are reversible errors, there are fundamental errors. So that's why you need an appeals, an attorney that specializes in appeals. Because there's a lot. Okay, and let's see. It says, it says United States versus Cousinar, which is a case law. It says, unlike Rule 29, Rule 33 confers broad discretion upon a trial court to set aside a jury verdict and order a new trial to avert a perceived miscarriage of justice. But such discretion should be exercised sparingly, meaning, remember I tell you about it, you got to reach a bar, probably have some tests in there, all that bullshit, okay, before they even think about applying this, because they're not going to just overturn a verdict of guilty based on, what may be considered a harm. What they're not going to do it for is harmless errors, okay? Harmless errors. They just, present a remedy for that, okay? But harmless errors, okay, let me think now. Harmless errors don't get a review on direct appeal. I don't know where she's going with this, but I'm just thinking out loud. So if these scenarios do play out, I will revisit what I'm thinking out loud. Okay, we might see it, in the upcoming filing. So who knows? All right. It says Jane testified as the government's star witness at trial on August 19, 2022. During cross-examination, defendant's counsel questioned her about her expectations of restitution in the event defendant was convicted. Question: and isn't it true that the U.S. Attorney's Office told you that you would be entitled to restitution if Mr. Kelly was convicted, right? Answer, yes. Question, and restitution is money, right? Answer, yes. Question, and you are seeking restitution or will seek restitution if he is convicted, right? Answer, I'm still undecided with that. No, that is not correct. I don't know why she say that. Question, you haven't decided whether you're going to seek restitution? Answer, no. Question, but you know you have the right to seek restitution, correct? Answer, that is correct. 3. Jane's testimony was not truthful when she claimed she was undecided about whether she would seek restitution from the defendant. She knew full well she was seeking restitution in an extraordinary amount if the defendant was convicted. The government knew it too. Now, keep in mind that you have to prove all of that. You just can't throw it out there and say, boom, you get a new trial. You got to prove all of that. Well, hold on, let me take that back. The judge has discretion at this point to make you prove it, but they could set it for oral argument, something like that. So let me change that. Let's see. Okay, so number 4, prior to Jane's and her parents' cooperation with the government, they retained the legal services of Boston-based attorney Christopher L. Brown. Brown negotiated immunity agreements for Jane and her parents, and further retained an expert team to put together a restitution package on behalf of Jane for this court. Number 5, although Jane falsely claimed at trial that she had not decided whether to seek restitution, the government produced documents yesterday, including billing records from Jane's counsel, a 9-page letter motion from Jane's counsel arguing for restitution in the amount of roughly $20 million, and a lengthy expert reports that reflect that Jane absolutely knew of her intent to seek restitution from the defendant on August 19, 2022, when she testified otherwise. Not only did she know of her intent, she apparently invested $10,000 into assembling an expert team to prepare expert reports that support an outrageous request of restitution, nearly $20 million, as if she was litigating a complex civil case, absent the burden of proof and pesky causation requirements that would be required in a civil litigation, right? And we know what causation is, right? Causation is the cause and effect. The person's action, the but-for test that I was telling you that about in a criminal procedure. Okay, it says, not only did Jane give false testimony, the government knew her testimony was false and failed to correct it in violation of Nepew versus Illinois, a second such violation on part of the government. Okay, you see that? A second such violation on part of the government. Watch all that language. It's going somewhere. All right. Now I already know where it's going. And I done told you motherfuckers where it's going. But you're not listening to me. As Mr. Brown's billing records reflect, he began discussing restitution with the government in April 2020, more than 2 years before Jane testified at the defendant's trial. Oh, wait a minute. Okay, so if she hired Mr. Brown, and one of his jobs were to negotiate a restitution package, then J-Bo has a good point. The government did know and probably should have corrected her or asked questions, pertaining more in depth with regards to this restitution package, right? So she could say yes or no. Now, whether or not she, planned at the time to go through with it, that would depend on um the motive and intent of the Jane on the stand. I'll get there because that has something to do with perjury, because I know this is where this is going. But I'll get there. It says, oh, she got a point. God damn, J-Bo catch every goddamn thing. She wear glasses on. It says Jane, through her counsel, retained two experts, Dr. Cooper and Dr. Smith, in February 2021. Prior to April 2022, Jane subjected herself to a so-called independent evaluation by Dr. Cooper, a forensic pediatrician, retained and paid for by Jane, who prepared a report on April 30th, 2022 that is entitled Expert Opinion of Dr. Sharon W. Cooper regarding victim Jane Doe, United States versus R. Kelly, April 30th, 2022. In her report dated April 30th, 2022, Dr. Cooper declares that one of the purposes of the report was to determine restitution. 7. Oh, wait a minute. Hold on. Did J-Bo say... Okay, J-Bo said Mr. Brown was hired, and one of his duties was to put together a restitution package. I think I read that. And this lady is further support and said one of her jobs was for the purpose of determining restitution as well. Okay. Number 7, on August 12, 2022, Mr. Brown had more discussions with the government related to filing for restitution. On that same day, an expert report from Dr. Smith of Smith Economics was submitted to Mr. Brown that reflected his lengthy opinion, in which he calculated the value of certain losses subsequent to the injury of Jane. Number 8, Jane, through her counsel, Mr. Brown, paid these experts roughly $10,000 for services rendered prior to her testimony on August 19, 2022. Number 9, in light of the foregoing, it is simply not believable that Jane was undecided about whether she would seek restitution from defendant when she testified on August 19, 2022. The documents submitted by the government show that Jane was significantly motivated by the prospects of restitution to the tune of $20 million, and the government knew this. Okay, before y'all start going crazy, that does not mean that does not mean that by her testifying, knowing that she's going to get, she is entitled to some money if he's found convicted, means that the nature of her testifying, it was some kind of coercion or anything like that, because I know how y'all do. Y'all will loop it together. Then that's not how it works. Because when people testify in civil lawsuits, and 9 out of 10 times money is a factor in those cases. Okay, it's comparable, what I'm talking about. Okay. Hold on 1 minute. I don't know why I feel the need to eat some of these peanuts. Give me a minute. Okay. Wait a minute. Number 10, as defense counsel pointed out, Jane's motive and bias was a fair area of cross-examination. A motive of $20 million is a particularly strong motive that defendant should have been able to explore with Jane. Like I told you, when you allegedly prevent the defense, from information such as this, then you hamper their line of questioning, right? Which can affect their case in the long run. Because if you don't know about this, then you can't question it. Now, here's the thing. If they knew about this, then that just blows a hole in the whole Brady, Giglio, and the Pooh violation, right? If the defense knew about this. All right? Now, whether or not it was in the discovery or not, if the defense counsel knew about this, so if the prosecution had some type of paper trail or something like that where they shot this information over in some form or fashion to somebody on the legal team, no matter if the legal team has changed hands, then that information was discoverable. It's could be discovered by either side. You knew, we knew. Okay, let's keep going. The government should have disclosed Jane's intent to seek extraordinary amounts of restitution, which apparently was the reason she ultimately cooperated with the government. It certainly was obligated to correct her false testimony on this point. Instead, it sat silent when Jane was less than honest about her interest in restitution, denying defendant his right to cross-examine her interest, bias, and motive. Bam. Remember I just said, now, here's the thing, right? J-Bo is good. She good, baby. Girl, I got you, though. I got you. When it comes to perjury, I knew this way it was going. This goddamn woman's good. Oh, she good. When it comes to perjury, right? Someone may lie on under the penalty of perjury or under oath. The judge has discretion in that area because they're going to say, well, listen, what was the motive? What was the intent? Keep in mind, someone being unsure, mistaken about the facts or something like that, that does not rise to the level of perjury. Okay? Two different things. Remember I told you it's a lot of rules and tests and all that bullshit and standards and all that stuff like that goes into this, right? Goes into this determination shit. I swear for God, I probably should have just stuck with the elements and just kept going over the elements, because baby, I'm getting into the weeds with this shit with y'all. Y'all gonna be like, huh? But hopefully I'm transferring it in a simplistic way that you guys can understand what and I have to hesitate sometimes because I want to substitute the Merriam Webster words for a word out of the law library. So, but anyway, yeah, so right there, when she adds that word motive, she's saying right there the defense was denied the right actually to cross-examine her. So if the prosecution comes back and say, just what I said with regards to perjury, it gets down to the motive and intent. She's saying already, well, you denied us the right to cross-examine her, so we don't know what her motive or intent was, and now that opportunity is lost. Mm-hmm. Can't fool sister girl. Nope. Number 11. The Supreme Court has held that a conviction obtained through the use of false evidence known to be such by representatives of the state must fall under the 14th Amendment, Nephew versus Illinois. See also Giglio versus United States. It says new trial required when government failed to correct false testimony by key witness about a benefit he received for testifying, and the prosecutor should have been aware of the falsehood. Ooh. So listen to that. Listen to that burden, right? That right there is a burden. Okay, when it says he received the benefit he received for testifying, and the prosecutor should have been aware of the falsehood. So she's right there saying, in this particular case law, whether the prosecution say what they knew or they didn't know, whatever, they should have been aware. Go ahead on, J-Bo. Hey, it ain't over. I hear Teddy Riley. Part ain't over. It says the same result obtains when the government, although not soliciting false evidence, allows it to go uncorrected when it appears. She cites Nippel again. It says when a conviction is obtained through the knowing use of false testimony, it must be set aside if there is any reasonable likelihood that the false testimony could have affected the judgment of the jury. Now, this is when she might run into a little trouble. Okay, because remember, that is the standard, right? That's the high bar. Number 12, the government will likely argue that Jane's testimony denying her strong interest in restitution could not have affected the judgment of the jury. That's what they're going to say. Even if this was true for the child pornography counts, Jane's credibility was critical in various other ways, meaning they were denied to raise reasonable doubt through knowledge of this information, including whether she participated in sex acts with her friend Pauline and the defendant when they were underage rather than when they were the age of legal consent. Oh, J-Bo good. J-Bo is stringing all this shit together. Go ahead on. Baby, I tip my hat to you. Go ahead on. Bitch, you can write. You can write, girl. I ain't mad at you, baby. Yes, honey, yes. Let them all be jealous and die of their jealousy. Yes, because your ass ain't going to people's school. Yes, she is good, baby. She is good. Yes. Okay, it says, okay, to credit the story that Jane, Pauline, and defendant had so-called threesomes in the face of contrary evidence, the jury likely credited Jane's testimony on this point, meaning, again, with the knowledge of this information, she's saying that, hey, she was able to pursue a line of questioning that could have called into question Jane's testimony on that stand. It could have been a game changer for the defendant, right? Yes. Let's see. It says, thus, Jane's credibility was important to this count of the indictment, and her testimony questionable where the defense presented evidence that any threesomes that occurred were after the young women were of legal consenting age. Indeed, in her so-called independent examination with Dr. Cooper, Jane failed to disclose any of the threesomes that she testified about at trial, which is arguably itself a Brady violation if the government had access to that report. In short, the jury did not accept Jane's testimony hook, line, and sinker on all matters. Thus, testimony that could have further impacted her credibility, such as her motivation to shape her story in ways that were not entirely honest because she stood to gain significant restitution, as did her friend Pauline, was material, which means it was important to the elements and the facts of the case, which is the facts of the case, and could have affected the judgment of the jury. Now, here's the thing, right? The government probably also going to say, listen, you can't say, you're trying to say that you are weighing the outcome of this case based on this particular objection you're raising now, this particular argument, right? They gonna probably have some kind of supporting case law or something, or maybe just write it like this. This they'll maybe I don't know, and I don't want to hear no bullshit about me calling nobody or talking to nobody because I don't know nobody. Okay, I'm just telling you how I can go. About them putting the weight on this one issue, they may come and say, well, I mean, that's the design of your case. We don't have anything to do with that. If you are designing your case that way, then that's on the defense. That's not our, now she can come back and say, but you left us no choice. She can come back and say that. J-Bo can say that, but you never left us no choice because you left this information out. Okay? You failed to disclose it. So, don't know how it's going to play out. Number 13, although defendant will raise this issue in his sentencing memoranda, restitution is not meant to be a substitute for emotional distress, damages, or punitive damages. The inherent and primary purpose of restitution is to compensate the victim of a crime rather than to affect the criminal in some way. Restitution is not intended to be punitive. And it says the Seventh Circuit of 1998 awards are designed to compensate victims for losses rather to serve retributive. I'm sorry, I'm backed up from the goddamn screen. Serve retributive or deterrent purposes. 14. If courts are going to permit the government and victims to use restitution statutes as a means to end run civil litigation and compensate victims for emotional distress or to punish the defendants, then courts also need to consider whether ex post facto rules should apply and whether the defendant has the right under Brady to know if the government intends to seek outrageous sums of money in restitution. So right there, she's asking a whole big old thing of the interpretation of the law from the judge, right? Okay. And let me see how is she applying ex facto rules. Let me see how she's applying this. Okay, she says statute run civil litigations and compensate victims for emotional distress. To punish defendants in courts and also whether ex facto rules should apply. How is she saying ex post facto rules should apply? How would this fall into ex post facto rule? The statute hadn't run out before it was amended, so that's not it. There isn't a new, an ex post facto does not apply to new laws that the state or the federal feds enact. So I don't know how she's applying that. It is difficult to deny that the $13 million could be a very strong motivator for victims, witnesses, and could reflect on the credibility of a witness. Number 15, these issues will be fleshed out further in defendant's sentencing memorandum. But for the purposes of this motion, defendant maintains that James' false testimony regarding restitution and the government's failure to correct it denied defendant of his due process rights, as well as his Sixth Amendment right to confront his accuser about matters that reflected on her credibility. For the foregoing reasons, the court should deny this trial. Oh, okay. Oh, so just like before, right? We get it. We do our own shady investigations over here, baby. Our own in-house investigations, honey. This is the one-stop shop, baby, where you can hear about an Alexander Wayne pocketbook as well as figure this shit out. Okay, let's see. Now, let's see when people knew about this shit with this Mr. Brown. Mr. Brown. All right, by his legal fees. All right, it says, my name is Christopher Brown, and I make this affidavit under the pains and penalty of perjury. I am over the age of 21 and I'm the managing member of Brown and Rosen LLC. I am an attorney licensed in New York and Massachusetts for over 20 years. I am lead counsel in this action and I make this affidavit based on my personal knowledge. I graduated from Boston College Law School in 1998 and I am in good standing with the New York and Massachusetts bar. Came out same time I came out. I graduated from okay. I have practiced business litigation, civil litigation, intellectual property litigation, and other areas of law in New York and Massachusetts. Okay, so he does civil shit. In 1997, I was a student prosecutor in Middlesex County District Attorney's Office in Massachusetts. Go ahead and count your little motherfucking shit, honey. I couldn't even get on the law review. It says, I have been an adjunct professor at Boston College Law School since 2002. Oh my gosh, did you take this off of me? Okay, it says, based on my experience, I am familiar with the legal rates in my areas of practice. And just so y'all know, that's like teaching school, being being both an attorney for the defense and the prosecutor, uses the state, whatever. It's almost like a damn package. You understand what I'm saying? It's almost what your ass would do. Your ass will end up being a junk professor, okay? But if you don't want to go and just normally, those people like me don't have practices and things of that nature, right? But he apparently has a whole he getting all the money. In other words, he getting the school money, he getting money from the goddamn his law firm, he getting all the money. And his ass did a little stint in there as a prosecutor. I ain't mad at him. It says, based on my experience, I'm familiar with the legal rates in my area of practice. In 2019, 2020, my legal rates was $500 per hour. Y'all are cheap up there. In 2021 through 2023, my legal rates was $550 per hour. I am counsel to Jane in the above caption action, a victim of the defendant, Robert Kelly. And his rates are probably that rate because he most likely, ain't no most likely, he charges a percentage on his actions, right, and his on his cases. Okay, so that's probably why his rates are cheap like that. It says the invoice at Exhibit A indicates the fees and expenses charged to plaintiff for prosecution of the copyright claim in the amount of $54,468. Copyright claim. Oh, what she got a copyright claim for? Oh, it says the expenses are reasonable and account for 81.3 hours of time allocated in this case for the prosecution of the defendant and representing RL from 2019 to 2023. I personally prepared the bill for this claim. Now, and I don't know if anybody feel like doing it, but does anybody want to figure out what 33 and a third of $54,468,000 versus let's make a mid range, $525 an hour for 81 hours. Hold on, I'm nosy as hell, and I just want to count his pockets. Sorry, y'all. Okay, 81 3 times $525 equals $42,276, right? I think that's right. Hold on. Right? 10 is no. Yeah, that's right. That's right. That's right. That's right. Okay. So and the okay, so it's 42,276. Okay, so we're gonna do 55,000 times. Okay, so I see why he's charging her hourly. He's okay. I see why he's charging her hourly. And now I'm just getting ahead of myself because sometimes they can start challenging the his price. So I'm just getting ahead of myself while I'm doing it, right? Because I ain't going back over this. Okay, so got to pay attention to the dates, right? This is from his office, dated January 23rd, 2023. He is submitting how much he charged. This is what he charged them. Mm. So, okay. So, ooh, $43,000. Yeah, that's a good lick. Now, this is expensive. So, I knew she ain't paid for this up front, right? But by right, J-Bo doesn't have to say, you know, this was it was it was like a deferred payment or whatever. She don't have to say that. All right. But I knew damn well if the girl is in the Section 8 hiding out allegedly, if she didn't have money to move herself, I know damn well she ain't had no 10, 11 grand to pay nobody to prepare something that, it wasn't no guarantee. You understand what I'm saying? That she would, that the government would prevail, right? And then therefore she would be entitled up under uh, the restitution portion of the what's the sexual victims act or whatever it's called. So now he okay. So I see how J-Bo came to her conclusion. She's using the dates. She's saying that she knew good goddamn well she was planning on going after some money because the first date is April 9th, 2019. And it says, meeting with Jane in Chicago, fact gathering relating to R. Kelly from clients. So what was his role? Let me see when it got. Does she say anything about? Does he lay out? Oh, no, 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 no. Okay, wait a minute. He was also hired to discuss the immunity package. I'm sorry to be all over the place, but with J-Bo, baby, that's what she have you. The immunity package. Let's see. I ain't trying to help her out. I'm just trying to get my thoughts together. Okay, restitution. Oh, so I can keyword restitution. Hold on. Let me do keyword restitution in here. We need to see when they first started talking about restitution. And I'm gonna go back and read those footnotes too. It'll probably tell me what I need to know. Okay, wait a minute. Okay. Ooh, when she testified, they her first, it looks like he got a memo. Now this his motherfucking memo. This ain't me fucking it up. On April 26th through the 28th, 2020, restitution came up. Now, here we go. Now this looks different. Okay. J Bo has some merits to her claims in here, right? Oh shit, I ain't see it said discuss with United States Attorney's Office. Oh shit. oh, oh, she got merits on merits. Okay, let me tell you why. Now she can kind of use this and say, hey, the United States knew that she was gonna motherfucking she was seeking restitution. Yeah. The only thing about it is, one, did they fail to disclose this information to the defense? And two, did the defense know about it during the trial? Did they know about it? Ooh, the response to this is gonna be so good. Ooh, ooh, oh. Let me read these footnotes before I get right now, because I'm not running that with y'all. Let me read these footnotes. Yeah. J Bo be looking. Y'all leave that goddamn lady alone. Don't come go fucking with that lady. That lady is finding goddamn needles in haystacks. Okay, let me read these footnotes. It says, according to submissions by Jane's attorney and her expert team, she believes she is entitled to as much as $20 million in restitution. Defendant will address what restitution Jane is entitled to, if any, in his sentencing submissions. And sentencing submissions mean the opposition to the PSI, the sentencing Miranda, the prosecution get the same luxury, the sending the same stuff, countering, of course, what the defense says. It all makes up sentencing submissions, right? Number two, Jane and her legal and expert team have no standing to argue for restitution or even to present evidence in support of restitution, as they are not parties to this claim. Courts have recognized that, notwithstanding the rights reflected in the restitution statutes, crime victims are not parties to a criminal proceeding. Case law. It says the First Circuit in 2010, crime victims have no right to directly appeal a defendant's sentence. Second Circuit 1990, holding that a crime victim lacks Article 3 standing to appeal under the MRVA. So that is the Victims' Right Association. So it says Third Circuit of 2012 says crime victims have no standing to challenge restitution orders. Crime victims, they just keep repeating itself. Standing on appeal, a rescission of restitution order. It says hold that it joins the first and third, the fifth, the eighth, and the 10th circuits in holding that a victim of a crime may not appeal a restitution order under the MVRA. So maybe she keeps referring to restitution orders because maybe the restitution that she seeks outlined in what J-Bo has submitted to us is more than the restitution order, that then maybe the possible calculation of the restitution order. Let me see if that's the case. Okay, courts have recognized that, notwithstanding the rights of reflected restitution statutes, crime victims are not parties to a criminal proceedings. Okay, hold on, that a crime victim. Okay. challenge the district court about rescinding restitution payments. Okay. Because that restitution and victims funding are two different things. It says, number 3, Mr. Brown also includes an affidavit which is a little puzzling as it references Jane's copyright claim and seems to have been prepared in connection with a different case. Boom! Go on, J-Bo. See how we look at shit? Now, I saw copyright too. So I want to know, what's the copyright claim? Number 4, Jane's request for restitution seeks lifetime care for a myriad of ailments that seem to have no connection whatsoever to harm allegedly committed by defendant. Number 5, defendant has only attached Mr. Brown's billing records for the purpose of showing the timing of Jane's direct involvement in developing a restitution package. That's why I was looking. See, that's why I went to looking at them dates. That's what we do. It says she belies her sworn testimony and the government's knowledge of Jane's strong interest in restitution. See, meaning, that's why I looked at that date. Then when I looked up and said the government knew, well, the man said it. On that day, I called out. Ooh. It says defendant does not attach Mr. Brown's letter motion or the 2 expert reports that Jane paid to have prepared because such information contains confidential medical information about Jane, but also because such evidence should not be considered by this court, where Jane is not an independent party to this litigation and has no standing to submit such materials to this court. Meaning the state, remember I told you the feds bring cases on behalf of the feds, not any particular litigant, any particular person, okay? See, when I be telling y'all over time, it all will connect and come back at some point, right? So it said these issues will be addressed later in forthcoming sentencing memoranda. Let me see how I show it. I mean, J-Bo be fighting to get Mr. Kelly money back, to hold Mr. Kelly money. You know, shit, J-Bo is a little fighter. I like her. I told you I like her. Okay, it says an independent medical evaluation is not an evaluation conducted by one's own retained expert or doctor. Ooh. Oh, let me come on around there with y'all. Let me drop that line in the chat. Ooh. Ooh. Hold on. They knew. Yeah, this is when it gets interesting. Hold on, let me pin this on up in here. This is crazy. What's up, James? Coming here starting trouble. But hold on. Hey. Okay. Sorry about that, y'all. But it's gonna get interesting. Hey, Henny, let me see who I missed some people. Oh no, I ain't. Oh, let me go back and look. Miss Henny. Hey, Cookie. Hey, Danny. Hey, Shawty. So let me go back and see how much they charge for the damn thing. You know what? See, I don't know where Atmos said. I miss going out to Atmos because he reads. Let me see okay, let's see. Meeting with clients, negotiation of immunity. Negotiation of immunity for clients is $1,500. Um, Let me see. Wait. This is, man. So we got the arguments. Did this information, would have changed the outcome of the case if known? Versus, is it a constitutional violation of his rights, of his due process? I tell you, she makes a good point. You got to challenge someone's credibility. I mean, the prosecutor can come back and say, well, that's the only strategy, pretty much that's the only strategy you got, challenging the witness credibility on stand. We shouldn't, this shouldn't be reversed because of that. Yeah, that's what the parents hate. Mo, what's good with it? Yes, I'm always on the straight and narrow. I'm being good. See, I'm being good. Listen, I'm not going to argue with people that can't spell and be out here lying and acting a fool. Now, I'm not going to do that. I have shit to do. Hold on for 1 minute. Yeah, that's for the parent. $1,500. That's interesting because that indicates to me that the parent doesn't have a separate agreement with him. So I don't know how he can legally claim that amount for the parents. Hold on, let me see if her and her parents retained him. Hold on, let me see if that. It's crazy. Give me 1 minute. Well, they said that he was negotiating an immunity agreement, not representing her, as representing the parents as their attorney, with regards to this particular case. He served in a specific capacity with regards to this case, right? It was apparently to negotiate immunity agreement, talk about a restitution package, and all of that. I'm gonna see if there's some black people. Let me see if what's the name of this this law firm. Not that it matters. I'm not saying it matters. I'm just curious. Brown and Rosen. Hold on. Brown. So, like I said, I do believe that all of these little things are foundation for a larger argument. Let me see if I can get a picture of them. business law. Let me see. White man, black man, Chris Brown. Mm-hmm. Did they go to school together? Let me see. Associated corporate. 10 years of people was a social corporate partner. Tesla. I have Joe as a partner of Icon Sports, but he represents professional baseball players. Joe received best in broadcast journalists from Syracuse. And the Boston Law School, and yep, they went to school together. See, I be knowing this shit. It's just how it works. They went to school together. Mm-hmm. Rosen and Brown and Rosen. Go ahead on. And Rosen got them connects because he represented some the baseball teams and baseball players, and he's also an adjunct professor at Boston. So they thicker than thieves, right? Mm-hmm. Mm-hmm. Yeah. So I don't know. See, and this is one of those things, right? Boy, I'm trying to tell you, it's so difficult when you don't have the files in front of you and shit like that, because of course, why would we? And we just getting a snapshot of what's going on in the case and what's going on in the minds of the attorneys, right? On both sides. And due to y'all questions and answers and shit like that, man, we comes up with what's going on. But this right here is sticky, right? Hmm. Let me look at something. Because depending on the type of error, certain things apply. Certain it's handled different ways procedurally, right? Let me look at something. Hmm. Hmm. So, okay, so she's claiming, okay, because again, she's trying to attach this issue to the prosecution, and and the dates are like clear that the prosecution no. The only thing that the prosecution is going to have to tell us, did they tell the defense about this? Was it shot to them or someone? Can they prove that the defense knew about this so they can, show there wasn't a Brady violation? Did dates are right there. They're gonna argue with, of course, this decision would not have affected the outcome of the case. But she's gonna argue her rights. I'm telling you. And then you see, she put in there, this is another quote unquote mistake by the prosecution, a violation. I forgot how she worded it. So we know how she's coming. We know how she's coming. This is crazy, y'all. This is crazy. We got our shit. I want them. Hold on. Let me see if the prosecution done responded. See, they not as quick as the ones that was in New York. The ones in New York, they was anticipating the bullshit, and they had it ready. Like, oh, okay. And she was ready too. The judge was ready too. Hey, y'all, let me ask you a question. Because I usually don't. I don't get into this bullshit out of here for that reason, because it's bullshit. But I just want to ask a question because I've already formulated in my mind what it is. But I'm just want to ask y'all, the people that usually that I know, you know, have good sense and pretty good judgment. What do you think the big deal the big deal is with this blood versus cuz shit or debate? And does it matter to you to the extent of, because I'm trying to tell you, if this is not confirming when I call these motherfuckers crazy and insane, I don't know what is. And no one is even, I would see better if someone was raising the argument saying, hey, I'm so focused on this because I was swindled. Hold on. Let me change it. Let me get my words right. I was swindled by this man saying that he's his cousin, this other man saying he's his mentee, and all these people saying that they the sisters and shit, the brothers and everybody. I was swindled because of that. Now it's still, you have to prove that, because if you don't, if it didn't, if your giving didn't come with a stated or a practice or implied intended result, then your argument goes nowhere in court. But I'm just wondering, like, what is it? So I can understand, because I don't want to, be looking at some of y'all crazy. I mean, now, if that's all you can do, I get it. Some people are limited on what they can do, what they can talk about, or what they want to talk about. There are clear different definitions when it comes to being nosy, jealousy, obsessed, shit like that. Clear definitions, right? Clear characteristics that further expound expands that definition, right? So with all of that going on, I'm just not that I mean, it don't matter what time of night. If they think somebody's going to talk about somebody ain't the cousin, somebody ain't the mentor, and the sister ain't the sister, they will stay up. I be like, hell no. It just ain't that serious to me. But just because it ain't that serious to me, it might not be, it's not that serious to you. So, personally, I don't see what the matter is. You're a fight for justice, Robert. Like you said, you don't care if it's a roach, right? To me, it's about who wants to be in the one YouTube streets and validate their worth, right? I don't care who call cousin, brother, sister. At the end of the day, this fool ain't getting out of jail no time soon. Oh Lord. But I mean, that's my thing, right? I am in nobody can tell me what to talk about, who to talk about, this, that, and the third. But based on what I'm talking about, that's gonna give a little insight into me and how I approach it and things of that nature, right? I'm talking about this haven't been going on just in 2 or 3 months. It's like 2 or 3 years. like what is wrong with you? And it's a good case on something that's fucking wrong with you. It's just my opinion. People like to be number one. And another thing, right? People that want recognition or want some type of gratitude for putting in work that they volunteer to put in. And even if somebody asks you, what are you doing it for? Are you doing it because you want the recognition? Then if you're a recognition driven person, that something's wrong with you, speaks to at least speaks to your character if something ain't wrong with your ass. If you stand up all night and you all depressed about not getting recognition, then something's wrong with you. I'm gonna tell you what it is, okay? I'm not, I'm not legally diagnosed no motherfucking body, but I'm telling you, go somewhere where the people got the right PhD on the wall and whatever, and tell them what you be doing out here in these streets, and see if they don't prescribe some Geodone or something for your motherfucking ass. Hey, CC's or something on you for your motherfucking ass, so you can get your ass on up out of here. Tell them the truth. Hot Rod, what's good with it? What's good with it? Mine definitely Afro-American brother. Hey, Hot Rod, where you get that hair from? Where you get that hair from? All of a sudden, your ass got hair. I'm like, well, who is that? You done been bald headed all this time. You done went through all these winters on YouTube in Chicago, bald headed. You weren't worried about covering your head then. Now all of a sudden you done come back, you got hair. I told your ass don't work nowhere. Now how the hell you come up with hair all of a sudden? I was like, who was that? I'm like, well, who is that Hot Rod brother that's taking over? No, that was your ass. Yeah, you have on and off hair like Samuel L. Jackson. That's another man. Samuel L. Jackson be having braids, all kind of shit. I don't get it. I'm like, is that from the costume people? Thank you, Hot Rod. Thank you. Yeah. Okay, wait a minute now. See, come on. See, people, y'all give me good answers over here. The mentee led us to believe that he was close to chaos in the beginning before we knew better. Then he used to bring validity to his arguments and to get others to fight his battles, ruin friendship. Oh, okay. What's up, Shaniqua? Oh, okay. Okay, it's not about to be a fan. Corrupt system is content is twisted order. Lies gone. I need not immunity when I tell the truth when I'm a victim. Well, here's the thing, right? Just because you are a victim doesn't mean that you cannot also be a motherfucking defendant. All right. So 9 out of 10 times, like I said, if you're looking for the process that Levi speaks of, the sterile process and all this and blah, 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 blah. He hurt a lot of us and turned us against each other by saying Kels was telling him things. Okay, let me finish my one thought, then I want to get back to you because I want to explore that a little bit. So, when someone is working out immunity and things of that nature, of course, that tells you that they could possibly have an indictment. But they decide to cooperate with the government and things of that nature, then hey, depending on how severe your shit is, we might either, hey, give you a slap on the wrist. We may lighten your sentence, things of that nature, right? See, we live in an imperfect world. So, of course, we're going to have an imperfect system. And because we have an imperfect system, there are remedies for just about anything you can get into. I mean, I don't like speaking absolute, but nobody knows 100%. No attorney knows 100% of the law and things of that nature. So, any dummy that thinks so, they are a dummy. Okay, probably one that can't spell. But no. I know I was gonna say. With regards to this perjury that J-Bo is pointing out, right? I kind of want to use this example to them goddamn BOP emails. So, if it's found that Rashana perjured herself, right? The judge could definitely create an indictment for her. It doesn't do anything to the case. What J-Bo is doing, because she knows that, she is trying to link it again to the prosecution. No, and did you see in her her brief that she is keeping count? Because again, what did I tell you she's laying foundation for? Somebody tell me. Y'all can word it any way you want to, but I can read it and tell if you got it. What I tell you she's laying a foundation for? Why don't we let James Harris answer that question first, since he's always in here disrupting. Let me know. You know, James? That's what I thought. So, but anyway, prayers for Kel. So, I'm trying to see, how do you get from, and I'm not challenging or anything, because I'm just trying to understand. How do you get from, okay, he told us stuff, and then I think you say he turned y'all against each other and lied to y'all, saying they made new kills and stuff like that. Well, that's like you ain't never been lied, and I'm not making small, of your situation. I mean, you ain't never been lied to before. I mean, you've been lied. I'm sure you've been lied to the people that that's been rapping your face. And how does, whether he knows R. Kelly or not, or or whatever, how does that ruin relationships and stuff? I'm just trying to understand. Because I mean, now you know he know him because a lot of you people have met him. And I'm talking about with regards to the mentee, Dana. Well, we know that. But now, the details of the relationship, I don't know nothing about it. But as for, we know at least he know him. Right? Oh, he said, Kel said that y'all shouldn't trust certain people. Oh. Well, that falls down along the line of being lied to and tricked, right? If that's the case. But how long do you stay on that though? And does it rise to a level of a criminal offense? Should somebody die behind it? I mean, what? I don't get it. I don't get none of that. Because you have a lot of people that were all down for the cause and stuff until people fell out or whatever. And that's when that's when the blueprint goes into effect. Okay, we're gonna attack your credentials, attack your credibility, we're gonna try to turn people against you, we're gonna try to do this and third, whatever, all for the sake of what? YouTube. Because what idiots don't know is that does not well, with some people, because some of y'all lost your jobs and all kind of shit happened, whatever. Maybe it played in your personal life. That doesn't happen and in everybody's life like that, because most people have their life set up in such a way where none of that would be even a fucking factor. But mental health is a goddamn hell of a drug. No, I ain't said you should forgive nobody. That ain't what I said. Oh, that ain't what I said. Right, Cookie. Right. Right. Kill people and shit. I don't know, honey. I don't know. Ooh, I don't know how that works. And then with the recordings, right? Now this is what I have a problem with the recordings. I think because the recordings don't say what some people want them to say, there is a problem. And some people, from what I heard, even turned on Mr. Kelly for what came out of Mr. Kelly's mouth. I don't, even if I was for or against him, just say if I was for him and he said what he said, me, a rational, stable person, wouldn't have a problem with R. Kelly or what he said or who he said it about. I wouldn't give a fuck. Because I'm going to do what I'm going to do out the kindness of my heart. I don't expect nothing back because I wasn't looking for nothing in the beginning. I went out here on no bullshit. I'm just saying if I was, and I can use that with regards to other things I've supported. Hold on. So, and I've never wanted, no, I don't need to be decorated, recognized, none of that shit. What I didn't get, I just have never been that type of way because I don't need all that to function. And I'm not gonna feel no kind of way. R. Kelly got millions of fans and thousands of people that want to help. There is no way in hell he can be expected to, okay, well, I'm in jail. I'm here for 30 years, but let me make sure I recognize it. That is crazy. And I'm saying it right now. You got to be a stupid motherfucking fool to think so. Unconventional dumbass. I'll tell you that right now. I don't give a fuck who gets offended. I don't give a fuck. What you gonna do? You retarded. And I don't want to really use that word, but I take that word out and use it for people that ain't about shit. That's crazy. I got time for that. I'm so glad I set my life up with it. Will never be able to tell me what to do or whatever. And you're gonna be nervous about making a suggestion, huh? Because I'm gonna read through the bullshit. I'm gonna ask so many motherfucking questions. You ain't gonna never make another suggestion to me. Because I'm gonna get down to it. What is this about? Because I know people be on that bullshit, and I don't like it. I hope not. I hope not. I hope he would never be. I hope he would never entertain no shit like that. And if he knew, well, he ain't got that type of heart. But I'm gonna cut you off, motherfucking queen. I see that you keep flooding me with a bunch of bullshit. You will be off my email motherfucking list, off my call log, all of that. You got to go. Because you are adding to my stress. You got to be, you can't always think about your ass. And if your ass didn't receive what you think you should have received in grade school, hell, you weren't on the motherfucking board, but the gold star by your name and shit. That's what we used to do to us when we was coming up. You do good, you get a gold star. Don't y'all remember how you tried so hard, you just wanted to be perfect to get that motherfucking gold star. And you see how what's that what more at? What's the what the reward and what is in psychology, the damn reward shit? What's it called? Who was it? Who was this? I know it wasn't Skinner, right? I know what is it, operant behavior? I don't know shit. But anyway, you get rewarded and shit. Like you should have got all of that in elementary, middle, high school. I don't do the motherfucking work. Like I feel, and I ain't taking away from nobody that don't, but I feel some kind of way if I gotta come out here and ask y'all for a dime to pay my goddamn stream yard and shit like that, when I can just simply cut it off. Don't do it. Like that's crazy to me. That is crazy to me. I don't get it. What's my, what you laughing about? But I'm serious. That's just the craziest shit to me. Now you got some people that give and take. I'm not talking about them people. I'm not talking about those people. But I ain't finna come ask you for no motherfucking bill money. That is ghetto as hell. I'm just saying. Like, god damn. Shit. Right. Red ribbons and shit. Hell. I'm, and I'm telling you, this is so crazy. When you teach and train and things of that nature, it doesn't matter what capacity you do that in. People have all types of needs and gratification and things of that nature. So I just systematically have always had a reward and award system in place everywhere I go. I get some good you could tell the ones that don't give a fuck about all that. I can get some good production I mean, but and then I know people some people have the need to be recognized. I get that. So I'm not the type of person, see, I'm a pleaser. You see what I'm saying? I'm not the type of person. So I'm not, that don't get lost on me. Even though I don't require it, some people need it. Because you don't never want people to feel any kind of a certain kind of way in society, right? You understand what I'm saying? See, I always tell y'all the story. I used to let the nerds sit with me, at like in the lunchroom and stuff like that, on the bus and shit like that. Yeah, I'm just, you know, conscious about people needing things of that nature. I don't know, but this is strange. But I ain't finna stay up all motherfucking night and shit about it and be acting crazy. I'm not finna do all that. Hold on, wait a minute. I'm missing some of y'all messages. Crazy. But I was just curious. You know, we ain't gotten into the shit over here about that shit. We're not. I'm just curious because I want to know how long is it gonna go. New Black, what's good with it? Oh, I don't know. Oh, ooh, oh, okay. But this shit along with personal shit, I gave over $40,000 in 15 minutes, 15 months. Oh no, Cookie, no, See, we can't no Cookie, don't do that. That ooh, see what I'm talking about? Uh uh It ain't gonna get me. It is not going to get me. I'm telling you right now. It is not going to get me. This shit here. Hold on, y'all. And listen, I'm gonna tell y'all. Hey Mo, have you? Is Mo still in here? Oh, I know she ain't the only college person. Um, but girl, are there any teachers or anybody in here? Let me ask y'all something. Have y'all ever had y'all class set up on Microsoft Teams? Oh my God. It goes on all day. Because let me tell you something. I believe in giving them what they need, and definitely, I don't believe in making shit uber hard for no goddamn body because I realize that they got more than one motherfucking class. But certain classes like have a that writing element where you got to have so many words and shit like that to graduate to pass the class and all that crazy shit, whatever. And you got to oh my gosh. And then like some business law projects and shit like that require like a team. Oh my gosh. And you got to get in there and girl, I can't explain. So y'all, that's I'm checking it now. So and it goes on, and that's why I fell asleep on Levi's. I fell asleep because all you kept hearing a ping, 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 ping. I'm like, God damn, shit. I was smart about mine. Instead of giving them an individual like project every 2 or 3 damn weeks, I made like one big project. So did. So did 103 pages. So did. What's up, Purple Purple? I appreciate you, Purple Purple. Girl, man, listen. As a person who has, you know how you identify your little personality and shit like that. So I do have, with some things, I do have an addictive personality. With something, not no high addiction, no shit like that, but just with certain things, right? And I believe that gambling could potentially be a bad thing for me. Because I want to go to one of them goddamn casinos and let it go. But I know if I lose over $250, honey, I'm gonna shoot the goddamn casino up. I'm gonna act a goddamn fool with that little bit of damn money. Hey, Lady Tech, that little bit of damn money. So I'm gonna tell you, you know that little what you call that little thing where you drop the thing down on the little bears and shit. And I'm gonna tell you, we was at the fucking bowling alley on Beach Boulevard. Check it out. It was, I forgot what time it was in the morning. I couldn't sleep. We couldn't sleep, and we were just doing stupid shit with blowing money. I spent $180 in that little thing, and to get 13 of them little motherfucking little fuzzy animals. I could win about that. Same thing when you go to the damn fair. Now, if you got somebody that knows how to win them little things and shit, one of them dudes that know how to win them little animals and shit, and you fine. Other than that, you got to get your stupid ass out there, try to bust the balloons and all that bullshit, and let the man swindle you out to keep trying and shit, and you got to cuss his ass out because you don't understand the rules of the play. Like, sometimes when I may say, okay, let me play this lottery. Like, we would go and buy the whole roll of the $5 tickets at Publix, just to make sure that we at least win our money back. No, yeah, but we buy the whole roll. We ain't buying just the ticket. We buy the whole roll. So I have to be careful with certain things like that. See, like a drink or that motherfucking shit, I can put that down any day. You know, I don't pick it up anyway often or anything like that. I did the other day. But that's not nothing I would ever be addicted to. And back then, honey, I was just doing it for fun. And when have time to, put it down, that's what the fuck I do. But so I have to watch that gambling element. But because gambling, that chance shit, I think is maybe the chance shit. I've been a fuck around and spent a whole bunch of money. Because now what I do, I like to see it I like to see it play out in investment. But even with that, I have to be careful. Because I be thinking, I say, okay, they say this is risky. Maybe if I put it in here for, and see if I can hit a lick and get the fuck on up out of there, Then if you do hit a lick, then you be thinking, well, maybe it can repeat itself. What's the projection on it? All of that. It's too much. Okay, well, let me see. I was a huge care support, but I had to back off dinner and some of us off. He had people calling others, husbands, friends, families, and jobs, blaming us for stuff, and had us attack. It's awful. Oh. She said, I use Microsoft Teams at work. We have channels for my employees and leadership teams. Oh, okay. Yes. Yeah, the YouTube streams would have gotten it probably if the cousin didn't call. I don't believe if I wish she would stay away. Oh. Listen, you know, I don't get into the boys club. I just hate that all of them are acting a fool. I ain't taking nobody's side. I ain't gonna stop talking nobody for this, that, and third, whatever. I like individual persons, you know. Mm-hmm. So what y'all think about the motion? I got mixed crew. What y'all think about the motion? You think, you know, did this have a good chance of doing something the other ones failed to do, or what? Hold on, yeah, she put a 29 and 33 already in there earlier. Oh, let me see. Let me make sure. Who it keeps pinging y'all? It keeps pinging. Wait a minute, it drives me crazy. Hey, okay, wait a minute. Let me see. I think she already put in a 29 and 33, but let's see. Which is a new trial, and pretty sure I read that, but let me make sure. I want y'all to tell me, do y'all think any of this gonna work? Yep. So she already put in. So anybody, she put that in back in November. So, mm, $13 million. God damn, that's a lot of money. Oh, let me see what SpongeBob said. Okay. I lost money trading crypto on leverage just like gambling. That's sure. Hey, SpongeBob, you ever heard of is it Apple Box or Apple Fix? Apple Box? Well, anyway, in 2017, the government exposed this place called Apple Box. What they were doing was taking people was sending like well, Apple Box was this place where they were washing cryptocurrency, right? A Bitcoin. Was it no, it's Bitcoin. And so what you do if you got dirty Bitcoin or whatever, you send that to them and they were already set up to do like, hold or whatever they do to like legitimate Bitcoin funds or whatever, and they wash it all together, whatever and shit. Yeah, and so the government got hold of their ass, and what happened was they were able to take control of it, open it up, and expose all the illegal transactions and to follow the money and to see who was controlling these different accounts and shit. Yeah, crazy. And what they'll do, well, you know this, they'll sit up there and just leave it up and not even, tell you or let the person that they suspect that's committing the crime, not even let them know, just let them, watch it and see what they do and whatever, because that's the best evidence that they collect themselves just by watching. That takes people out of the chain of custody, out of getting on the witness stand and all that type of shit. You gotta have no part in it. They're getting the evidence direct. And that's gonna be hard for someone to overcome that. It ain't like nobody turning the shit in. My addiction was telling me I would win and help kills defense. Oh Lord. Oh no, Cookie. Every day arguing with friends and family to understand injustice. Cute screenshots of me in the chat. Ninja East Oakland. Nigga, I don't know what you talking about. Cookie. I done done a few dollars. Thanks. I mute my notifications on the weekend and just know. Oh, girl. I've set this up maybe. I think maybe this is about like my third class. I had to set this up, and I hate doing this. God, I'm gonna have to watch a replay for promotion. Okay, I lost my lot of chickens and chickens. I buy a lot of chickens and never check now. You know what? Your country behind do that, but I ain't gonna lie. It took me a minute to check some numbers. It took me about like a month to check some numbers. I figured, well, okay, James. What series? I don't know. God, right. It's a crypto fund that's on a house arrest. Oh, really? I give some chance of being an honest student. I had a chance to be. I haven't heard of Apple Watch. I've heard things like that data NFTs were bought by money laundering. Yep. I had to step away. Wait a minute. Oh no, I was asking people, do they think any of these motions have a chance of getting where it needs to go? Pretty much, SpongeBob. Bonjean put in a motion for a new trial because she said that RL, this is in the Illinois trial now, that RL lied when she said that she didn't know if she was going to seek restitution, and she's saying that the prosecution knew this, but they failed to disclose that information to her. She's saying that her client was prejudiced because she didn't have a chance to, explore this on cross, right? As well, because they didn't know of the, know about the restitution. And she was saying that while the, prosecution may say, well, it wouldn't change the outcome of the case, they're saying that she could have used this information to make the RL's testimony less credible. Okay. So she was saying like she missed the opportunity to, raise reasonable doubt based on this. Now she raised Brady, Biglio, and Nephew with regards to this. So I don't know. And she did that to see if she could attach it to the prosecution to make it a prosecutorial misconduct violation, make it under prosecutorial misconduct, but I don't know. But see, What I was saying is, if it falls under harmless error, well, a harmless error have remedies, right? If it's a harmless error and is raised under undirect, then it doesn't meet the burden for a reversal. I don't know. I don't know. To tell you, be honest, I don't know. J-Bo will have you all over the place. Because she's so good with finding little shit. I mean, suppose she keeps on looking. Because if you look, you're going to find something. Because, say for instance, right? Just say if a defense attorney did not preserve like an error. I mean, that's not hard to get a new trial. You understand what I'm saying? So, shit. I mean, it's like it's just as simple as going through the records. That's what I be saying. Y'all be thinking like, well, it's over and whatever. And it is hard to, don't get me wrong, it is hard to overturn a guilty verdict. But it's not impossible. And the thing that you got to factor in that there's an attorney with that amount of experience, right, when it comes to the post-conviction phase. There's an attorney that's good with her wording. That probably combs over this shit day in and day out. That knows how to use her persuading fucking brief to address a whole bunch of shit. She don't never just centers on what it's about. She be bringing in and well, this and already happened before, and remember when this happened, and this, and I already put in the. Let me remind you, I already put in the brief. I already raised an objection about that, and this, that, and the third, whatever. Like in basketball, right? That's why your coach be hollering at you to get them down rebounds, right? Because chance favors you when that's gonna come out in your favor. The more times you have the ball, because the more times you have the ball, that's the amount of times you have to create something. That's why they be hollering back at y'all sorry asses when y'all don't be in there, don't be going for the damn rebound. Hell, sometimes I don't be understanding them goddamn them damn centers. Man, I'm just getting off on something else. Oh, okay. SpongeBob saying something. Let's see. I think the motion would be denied. Yeah, it doesn't change the evidence of the crime, right? Which I think the courts will focus on, right? In the Joe Darius case, they found prosecutorial misconduct, but no new trial. Right. That's what I was trying to convey. They can even find the prosecutor. I was trying to convey. They can even a couple lives. I think I was talking to Levi. They can even find prosecutorial misconduct. But that threshold is high. And they can find that prosecutorial misconduct, look at all the facts in the case, which is the evidence, and say that a reasonable jury would have ruled the same way, even if this hadn't happened. But SpongeBob, you got to think about it. You know, when they start to argue a fundamental miscarriage of justice, Kurt Holcomb gave the Kale a shout out for his birthday when I was typing in his chat. See, Shaniqua, I was talking about y'all the other line. I can be watching something and I see somebody from this sector. I don't care. It could be on somebody else's trial or whatever. And y'all fuck around and free R. Kelly. Hey, they could be in there talking about automobiles and planes and shit. Now I see one of y'all, free R. Kelly. I was like, Lord have mercy. That should be so damn funny. I'm serious. And especially in Tasha K chat. Tasha K haven't talked about R. Kelly in a minute, right? Since that last time or whatever. She do a show every goddamn day, just about. I believe, no, every week. And it be on a different shit. I see one of y'all, hashtag free R. Kelly. I'm like, they crazy as hell. That shit be funny, but y'all, let me get off here because you know what? I really, really, really need to go see. Oh, Malcolm K. Could the new motion give Robert less time? No, he would have to go through a new trial for that. He can also get more time. No, the new motion that's not a motion to correct the sentence. That is really done on appeal, mainly like when somebody's and they remanded it back to the courts for them to impose a new sentence or whatever. But if they find something incorrect with this sentence, but you think about what she had an option to give him. So that's probably never going to be the case. They can definitely make an argument that he was sentenced correctly. Oh, girl, listen. Shanika, where you been on Clubhouse? Because I just got accepted to that one where I was on the waiting list with that one where WAC 100 being let me get off here because these people gonna drive me goddamn crazy. Well, anyway, so maybe I'll have to come back and do a reread. I think I probably butchered it. I was eating peanuts, checking on these students and whatever. But I think I caught whatever it was the catch. It wasn't that long or whatever, but we'll see. Now, do you think he's going to? I don't know. The judge might, I don't know. He's so tired. He might address this like Judge Donnelly did the day of the sentencing. Or he might go early. He might go early. I don't know. I don't know. It's our channel by Angie. Whack, Whack be in there. Listen, Whack can make. I knew Whack. I didn't know what was Whack. What was Whack on when all this time he been going after Takashi 6ix9ine only to now represent him. But his wife, Whack's wife got the business affairs in order, honey. She has her business has contracts with some Disney productions and shit like that. Yes, I think they got some real estate. Mm-hmm. Y'all, mama done found the right peanuts now. It's over. I'm eating them all online. Okay. Anyway, let me go. This shit here driving me crazy. And I will talk to y'all later. Thank y'all for coming on through. Peace out. Be safe.